Constitutional bodies. Public Service Commission. There shall be a Public Service Commission for the Union and a Public Service Commission for each state. Two or more states may agree to have a joint Public Service Commission (JPC) for that group of states. Parliament may by law provide for the appointment of a joint state Public Service Commission after a resolution to that effect has been passed by the state legislature, or where there are two houses by each house of the legislature of each house of those states. An act made by Parliament or state legislature may extend the functions of Public Service Commission. The expenses of the Service Commission, including any salaries, allowances and pensions payable, shall be charged respectively on Consolidated Fund of India (UPSC), Consolidated Fund of States (State Public Service Commission). The expenses of the Service Commission, including any salaries, allowances and pensions payable, shall be charged respectively on Consolidated Fund of India (UPSC), Consolidated Fund of States (State Public Service Commission). Union Public Service Commission. Appointment of members. The chairman and other members of UPSC shall be appointed by the President. Office under the government. Nearly as may be one half of the members of every Public Service Commission shall be persons who have held office either under the Government of India or under the Government of State at least 10 years. Term of office. A member of UPSC shall hold office for a term of 6 years from the date on which he enters upon his office, or until he or she attains the age of 65 years. Resignation. A member of UPSC may resign his or her office by writing under his hand addressed to the President. Removal. Chairman or any other members of UPSC shall only be removed from his office by order of the President on the ground of misbehavior, and after the Supreme Court has an inquiry on reference being made to by the President reported that the chairman or such other member ought to be removed on such grounds. The President may also remove a chairman or member of UPSC if they are adjudged insolvent, they engage during their term of office in any paid employment outside the duties of their office. They are, in the opinion of the President, unfit to continue in office by reason of infirmity of mind or body. Suspension. The President may suspend from office the chairman or any other member of UPSC in respect of whom a reference has been made to the Supreme Court for enquiry. Holding of office. The chairman of UPSC shall be ineligible for further employment either under the Government of India or under the Government of State. A member other than chairman of UPSC shall be eligible for appointment as a chairman of UPSC or as a chairman of a state Public Service Commission, but shall not eligible for any other employment either under the Government of India or under the Government of a state. Functions. To conduct examinations for appointments to the services of the Union, to assist such states on request in framing and operating schemes of joint recruitment for any services. State Commission shall consult UPSC on issues relating to methods of recruitment to civil services and for civil posts. Principles to be followed in making appointments, promotions and transfers from one service to another. On all disciplinary matters affecting a person serving under the Government of India or the Government of a state in a civil capacity. On any claim by serving or has served members under the Government of India or the Government of state or under the Crown. On any claim for the award of a pension in respect of injuries sustained by a person while serving under the Government of India or Government of state or under the Crown. Reports of UPSC. It shall be duty of UPSC to present annually to the President a report as to the work done by the Commission. On receipt of such report, the President shall cause a copy thereof to be laid before each House of Parliament. The report shall also contain a memorandum explaining where the advice of the Commission was not accepted and the reasons for such non-acceptance. The chairman and other members of JPC shall be appointed by the President. Tenure. A member of JPC Joint Public Service Commission shall hold office for a term of 6 years from the date on which he enters upon his office or until he or she attain the age of 62 years, because it is state's Joint Public Service Commission. Resignation. A member of JPC may resign his or her office by writing under his hand addressed to the President. Removal. Same as members of UPSC. Suspension. The President may suspend from office the chairman or any other member of UPSC in respect of whom a reference has been made to the Supreme Court for enquiry. Reports of JPC. It shall be the duty of JPC to present annually to the Governor a report as to the work done by the Commission. On receipt of such report, the Governor shall cause a copy thereof to be laid before respective legislature of state. The report shall also contain a memorandum explaining where the advice of the Commission was not accepted and the reasons for such non-acceptance. Appointment. Members of the UPSC, President. Members of SPSC, Governor, State Public Service Commission, Governor. Members of JPC, President. Term of office. A member shall hold office for a term of 6 years from date of joining or till they attain 65 years of age. 62 years of age for SPSC, 62 for JPC. Resignation. By writing under his hand addressed by the President to the President. SPSC to the address to the Governor. JPC addressed to the President. Removal. By order of the President on grounds of misbehavior and after an inquiry by Supreme Court can be removed also on the grounds of insolvency, outside employment and infirmity of mind and body. SPSC same as of UPSC. JPC same as of UPSC. Suspension by the President. UPSC by the President. SPSC by the Governor. JPC by the President. Comptroller and Auditor General of India. COG shall be appointed by the President by warrant under his hand and seal. COG shall only be removed from office in like manner on the grounds as a judge of the Supreme Court by a majority of the total membership of that house and by a majority of not less than 2/3 of members of that house present and voting. Oath. Every person appointed to be the COG of India shall make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the 3rd schedule. Conditions of the service. The salary and other conditions of services of the COG shall be determined by Parliament by law. The COG shall not be eligible for further office either under the Government of India or under the government of any state after he ceased to hold his office. Administrative expense. The administrative expenses of the office of COG, including all salaries, allowances and pension payable to or in respect to of the person serving in that office, shall be charged upon the Consolidated Fund of India. Duties and powers. COG shall perform its duties and functions with respect to accounts of the Union and of the states along with public sector undertakings and public institutions. Audit reports. The reports of the COG relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each house of Parliament. The reports of COG relating to the accounts of a state shall be submitted to the Governor of the state, who shall cause them to be laid before the legislature of the state. Non-constitutional and non-statutory bodies. Quality Council of India. Quality Council of India was set up in 1997 jointly by the Government of India and the Indian industry, represented by the 3 premier industry associations: Associated Chambers of Commerce and Industry of India, ASSOCHAM, Confederation of Indian Industry, CII, and Federation of Indian Chambers of Commerce and Industry, FICCI, to establish and operate national accreditation structure and promote quality through National Quality Campaign. It is a non-statutory body. It provides technical support to both central and state government departments in implementing ISO 9001 standards as well as in undertaking process improvement projects. Administrative control. Department of Industrial Policy and Promotion, Ministry of Commerce and Industry is the nodal ministry for QCI, Quality Council of India. Okay. Law Commission of India, 7th Governing Council meeting of Niti Aayog. Cooling off period for retired bureaucrats. All India Service Death Cum Benefits rules under the Central Civil Services Pension rules provided for cooling off period of 1 year after retirement. Central Services Pension Rules Rule number 9. It applies to Central Service Group A officers. It prohibits some commercial employment of such officers for 1 year after retirement. This is referred as cooling off period for such bureaucrats. If the retired officer wishes to join commercial employment before 1 year, then prior sanction of central government is mandatory. All India Services Death Cum Retirement Benefit Rules 1958 Rule number 26. It applies to 3 All India Service officers, IAS, IPS, IFS, Indian Forest Service, provides for a cooling off period for 1 year after retirement. If the pensioner accepts private join within 1 year and without government sanction, then the central government can suspend whole or part of pension for specified period. What does commercial employment includes post retirement? It is an employment whether paid or honorary in any capacity including that of agent under company, firm, cooperative society, body or individual engaged in trading, commercial, industrial, financial or professional business, and includes a directorship of such company or partnership of such firm, but does not include employment under a body, corporate, wholly or substantially owned or controlled by government. Paharis as scheduled tribe. Gujjar and Bakerwals are opposed to G.D. Sharma Commission's recommendations to include Paharis in ST list. List of scheduled tribes in Jammu Kashmir: Balti, Beda, Bot or Boto, Brokpa, Drokpa, Dard, Shin, Changpa, Garra, Mon, Purigpa, Gujjar, Bakarwal, Gaddi, Sippi. Pahari community. Pahari community includes Hindus and Muslims and is largely based on the language spoken by them in the hills. They largely reside in Rajouri, Poonch, Baramulla, Anantnag and Kupwara districts. Although the Gujjar, Bakerwal tribes and Pahari community are born in the same social and cultural milieu, and the former Gujjar Bakerwal live a nomadic life, shuttling between Kashmir and Jammu regions with their livestock, while the latter Pahari are socially stratified, economically well off and culturally moved with caste and other ethnic divisions. Paharis are largely found in the region between the Jhelum and Chenab rivers in the districts of Poonch and Rajouri and in Jammu, and Uri of Baramulla district, and Karna and Tangdar in Kupwara district. Scheduled tribes. Framers of constitution realized that certain communities in the country were suffering from extreme social, educational and economic backwardness on account of the primitive agricultural practices, lack of infrastructure facilities and geographical isolation. Constitution of India in Article 366 Clause 25 prescribe that scheduled tribes means such tribes or tribal communities as are deemed under Article 42 of the Constitution to be scheduled tribes. Article 342 Clause 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by a public notification, specify that tribes or tribal communities are part of or groups within tribes or tribal communities as scheduled tribe. Article 342 Clause 1. Article 342 Clause 2. Parliament may be law. include in or exclude from the list of scheduled tribes prepared through presidential notification. Any tribe or tribal community are part of or group within any tribe or tribal community. Based on Article 342, Parliament enacted the Constitution Scheduled Tribes Order 1950, which contains a list of tribes or groups designated as scheduled tribes. This order is amended from time to time to include more groups or communities within the ST fold. Criteria to designate as ST. The criteria presently followed for specification of a community as a scheduled tribe are indications of primitive traits, distinctive culture, geographical isolation, shyness of contact with the community at large, and backwardness. While the Constitution is silent about the criteria for specification of a community as a scheduled tribe, the word and the phrase tribes or tribal communities are part of or groups within tribes or tribal communities in Article 342 have to be understood in terms of their historical background and background of backwardness, primitiveness, geographical isolation, shyness, and social, educational, and economic backwardness. Due to these reasons are the traits that distinguish scheduled tribe communities of our country from other communities. It considers the definition of tribal communities adopted in the 1931 census. These facts are the basis for the provision in Article 342 Clause 1, which mandates to specify that tribes or tribal communities are part of or groups within tribes or tribal communities as a scheduled tribe in relation to that state or union territory as the case may be. Thus, the list of scheduled tribe is state or union territory specific, and a community declared as a scheduled tribe in a state need not be so in another state. Presidential notifications under Clause 1 of Article 342 of Constitution are issued as the Constitution orders. Criminal Procedure Identification Act 2002. Criminal Procedure Identification Act 2022 provides legal sanction to law enforcement agencies for taking measurements of convicts and other persons for the purposes of identification and investigation of criminal matters. While the legislation was enacted earlier this year, the Ministry of Home Affairs notified it to come into effect from August 4, 2022. It also repeals the existing Identification of Prisoners Act 1920. The 2022 Act defines measurement, and it includes finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scan, physical biological samples and their analysis, behavioral attributes including signatures, handwriting or any other examination of accused by the medical practitioner at the request of police officer, or examination of person accused of rape by medical practitioner. How will the measurements help? Measurements and photographs for identification have three main purposes: establish the identity of the culprit against the person being arrested, identify suspected repetition of similar offences by the same person, and to establish a previous connection. Reasons to introduce the Criminal Procedure Identification Act 2022. The Identification of Prisoners Act 1920. The Identification of Prisoners Act 1920 was enacted to authorize the taking of measurements and photographs of convicts and other persons. The term measurements used in the 1920 Act is limited, as it only allows taking finger impressions and footprint impressions of limited category of convicted and non-convicted persons and photographs on the order of a magistrate. 1920 Act limited the category of a prisoners whose records could be taken. Thus, it was considered necessary to expand the ambit of persons whose measurements can be taken, as this will help the investigating agencies to gather sufficient legally admissible evidence and establish the crime of the accused person. The Criminal Procedure Identification Act 2022. In the present time, modern technology allows to capture and record appropriate body measurements with the help of forensic experts. The Act provides for legal sanction for taking appropriate body measurements of persons who are required to give such measurements, improve efficiency of investigation, and will also help in increasing the conviction rate. It is for these reasons the Act seeks to expand scope of measurements to include finger impressions, palm print and footprint impressions, photographs, iris and retina scan, physical, biological samples and their analysis, etc. Empower the National Crime Records Bureau to collect, store and preserve the record of measurements and for sharing, dissemination, destruction and disposal of records. Empower a magistrate to direct persons accused of criminal activities to give measurements. Empower police or prison officer to take measurements of any person who resists or refuses to give measurements. Arrested persons will not be obliged to give their biological samples unless they have committed an offence against a woman or a child, or an offence punishable with a minimum of 7 years of imprisonment. Minimum of 7 years of imprisonment. The record measurement shall be retained in digital or electronic form for a period of 75 years from the date of collection of such measurements. Destruction of records. A person whose measurements were taken but has not been previously convicted of an offence punishable on any law with imprisonment for any term and is released without trial or discharged or acquitted by the court after exhausting all legal remedies, then all records of measurements taken shall be destroyed from records unless directed otherwise by the magistrate.